Yes, Mr. Pitt.
My lady and my lords, can I begin the afternoon by correcting a fact and then giving you a reference? The fact I must correct is that I said that the third of the school fees,
Yes.
which was for her £9,000 a year, the school fees were in total about £9,000 a year, perhaps a little more.
Which had
She paid a
crossed my
third
mind
of
that might have been a rather
It occurred to me
figure.
when I left the room that it seemed a lot for a day school, but and we checked, and so I was wrong, and I apologise for that.
Okay. Right.
The reference was, and this may be more important, is the case in which to which I referred before the adjournment, where overly close textual analysis of judgments is referred to, is the case of Waggett. It's in the authorities bundle, page 319. The memory stick number is 641, I think. It's paragraph 66 of Waggett, where Lord Justice Moylan says, my Lord Wilson is looking for the volume, and I'll just wait until my Lord has it.
Thank you. There are quite a lot of observations.
Good, so I'm sure you could find House of Lords authority for the same problem.
Certainly could. But it happens to be in the cases before your Lordships in these bundles.
So you gave us a page reference.
Yes, it's tab 30, page 319, tab 20, sorry, page 319. We think memory stick number 641.
It is.
Paragraph 66 of the judgment of Lord Justice Moylan.
Tab 20,
Tab 20, my Lord.
that's Morris.
Case-
21.
Oh, sorry, 21. I'm so sorry. Morris is such a short case, I missed the
Right,
rest of it. I beg your pardon.
okay.
Paragraph 66 of the judgment of Lord Justice Moylan.
Yep.
Saying, during the course, in particular Mr. Turner's submissions, it sometimes seemed as though the court was being invited to undertake a detailed textual analysis of what has been said in some of the cases, notably Miller, in a manner similar to that which might be applied to when the court is required to interpret a statute. I would question whether such a detailed scrutiny is apt and properly reflects the difference between the drafting process for a judgment and that for a statute, and their different roles in the administration of justice. I also mentioned that even in the interpretation of statutes, the court could take a broad purposive approach. It then goes on to say, in the context of financial remedy applications, the court is giving guidance. Guidance can, of course, be given with a degree of specificity. It's perhaps obvious to say that one cannot expect judgments to be written in the expectation they'll be analysed as though they were statutes. This does not suggest that precedents cannot create binding authority. The issue I'm addressing is how those precedents are interpreted and applied. And that goes, I submit, to the question of the word mismanagement. One of the interesting documents in the bundles is my Lord Wilson's lecture to the students at Bristol. And in that lecture, my Lord refers to starting out in practice in the late 1960s and being in a case where the conduct of a wife was crucial to the outcome to the financial proceedings. And the notion of punishment, the notion of innocent and culpable wives, has an unfortunate shadow, perhaps, when looking at how to address the conduct of a wife in a situation such as this. Nevertheless, looking at the word mismanagement and wondering how that should be interpreted creates a problem in trying to derive what is meant by an authority. It's easy to understand what is meant by prodigality, profligacy, or wantonness or recklessness. But one person's mismanagement is another person's acceptable risk-taking. And if this isn't sorted out by this court, it leaves a very ambiguous word, leaving open all sorts of potential litigation over whether conduct is mismanagement to the level that it has to be taken into account so as not to increase or extend periodical payments, or whether it's mismanagement of the sort which is acceptable risk-taking or misfortune, which does allow, according to the argument made by Mr. Cayford, for continuing periodical payments or an increase in periodical payments. That goes back to the point I was making before the break, which is that, seen in its context, the word mismanagement must mean more than merely unwise. It is unwise to sell your ground rents, ready money being paid on a monthly or quarterly basis, and invest it in a volatile stock market. But that was not what Lord Justice Thorpe thought was culpable conduct. That conduct did not and should not result in cutting, ending, or failure to increase periodical payments. It was the wantonness and recklessness of that wife which led to that potential outcome in that case, albeit it still didn't stop as a matter of principle, the matter being looked at by a court de novo. So that's why we say that mismanagement is a difficult word, but must surely be interpreted as meaning something which is culpable, wanton, reckless, profligate, or prodigal. Otherwise, to use an old word, I'm afraid, floodgates of litigation may open. The rummaging through the attic of marital conduct, all of the problems that we have in conduct issues in financial relief claims generally could be opened up by an ambiguous word not being given a clear meaning and carrying with that the notion of culpability or something like it. So in other words, that's what we say about that element of North and North. Coming on to the other elements of North and North, Lord Wilson asked me a direct question before the break when I was looking at the difference between paragraph 33 and paragraph 34 of North and North, the misfortune versus misconduct dilemma. And my Lord, you asked me, is that what Judge Everill had in mind when looking at paragraph 71 of his judgment, where he said that the husband should continue to pay periodical payments. It's fair that he should do so, but to reflect the fact the wife has lost all her capital and now has a need to rent, the contribution which the husband makes should do no more than enable the wife to meet bare minimum needs. Periodical payment should be aimed at alleviating significant hardship. So it seems as if Judge Everill is looking at that dichotomy and making a decision based upon it. But may I, my Lord, say this about that? First of all, as the Court of Appeal identified, he doesn't say so. He identifies her basic needs as £1,441 per month and does not give her that sum, doesn't say why, and doesn't address the difference between paragraphs 33 and 34 in terms, in simply saying, I'm not going to increase the sum she gets. He says she needs to meet her bare minimum needs, but having identified them, doesn't allow her to do so. That's the fault that was seen by the Court of Appeal. And that's why the Court of Appeal increased the sum in the way that they did.
Well, is it right that he didn't say why, Mr. Fearn? I mean, this may be the central point in the entire appeal, because that was the basis on which the Court of Appeal reversed him and went back to the to the demonstrated needs.
Well,
what's 72 if it isn't saying why? Or for that matter, 71?
Well, both of those, you can take both of those paragraphs together. And the difficulty with the judgment is this, that after 2 days of evidence and a thorough analysis, at paragraph 61 to 65, in particular, though there are some other paragraphs too, the judge identifies the budget and describes the budget in paragraph 65 as very modest, though it includes the cost of renting, it excludes rent in relation to the child, but describes it as very modest. And then over the page, at paragraph 70 on the following page, describes this as a budget figure set to meet only her basic needs. So the basic needs are identified as £1,441 per month. Those are the basic needs. In paragraph 71, he says that he should pay such as to enable the wife to meet her bare minimum needs. Well, he's identified what those are. The periodical payment should be aimed at alleviating significant hardship. But if you look at the difference between £1,441 and £1,100, a £341 difference, that's practically a third of what she was due to receive, between a quarter and a third of what she was meant to live on. And to not have between 25 and 33% of what you require for your basic minimum needs is surely a significant hardship. And it was that I was about to come to.
So are you saying that a husband who can afford it must always meet an ex-wife's basic needs?
I'm coming to that very point, my Lord, by taking the court to SS and NS in the authorities volume. And whilst it's a first instance decision, It is one from one of the most experienced financial practitioners and judges in the division. And I'd ask the court to look at tab 17, paragraph 31. And this, we say, addresses that point head on.
I'm sure you can give me
An MS number.
yes.
Yes, 576. Sorry, my lady. It's there that that's actually before Mr. Justice Mostyn gives the sort of well-known set of guidelines that he does later in the case, but he takes head on the notion of, in this particular case, a relationship-generated disadvantage or relationship-generated needs. Can I pause before looking at the paragraph and address why I'm asking you to look at this? Mr. Cayford's case, the case put in the written case and made to a degree already today, is that the need for rent in this case, and the need for that portion of rent that isn't allowed for, is not a relationship-generated need. It is a need generated by the wife's mismanagement of her funds. If that's right, there is still a consideration which has to be had to her need. All the cases, as I've said already in this case, all the cases referred to, generally speaking, certainly the three we're dealing with now, deal with cases where there is a surplus of income and capital, certainly over basic need. This is a case in which basic need is the keystone. Paragraph 31, looking at relationship-generated disadvantage or otherwise, first of all refers to the case of Fisher and Fisher, where the assumption of other obligations or obligations for other people's families was sufficient to allow a wife to seek an increase in periodical payments, certainly not an ending of them. That, in that case, Lord Justice Purchase said a recipient spouse without income but with an earning capacity should not be allowed to rely on the existence of an after-acquired dependent spouse or dependent children, was the argument. Purchase LJ, who held that flies in the teeth of the express provisions of section 31.7 to take into account all of the circumstances of the case and is not supported either by authority, reasoning or logic. The argument would apply equally to a person who become incapacitated from owing to accident, injury or illness if the exposure to such resulted from a voluntary act. In a similar vein, my Lady Hale is quoted, the most common source of need is the presence of children whose welfare is always the first consideration, or other dependent relatives or elderly parents. So there, my Lord, Mr. Justice Mostyn quotes the Court of Appeal and the authority of, I think then my Lady, the House of Lords in Miller, to, first of all, say that section 31.7 is very wide, which was the Court of Appeal decision in Fisher, but also to make the point that my lady does about the resulting of need from particularly the presence of children and other circumstances of the marriage. And he goes on to say, my Lord Mr. Justice Mostyn goes on to say, I find it difficult to see why it is just and reasonable that an ex-husband should have to pay spousal maintenance or enhance spousal maintenance by reference to factors which are not causally connected to the marriage, unless one is looking at the issue in a macroeconomic utilitarian way and gives a sort of public policy argument as to why a family rather than the state should care for its former members. But he goes on to suggest this, even this, if I may say so with great respect to him, the slightly hard line taken by Mr. Justice Mostyn compared to that of Lord Justice Purchase, says, I would suggest that in such a case, where there is no causal connection, spousal maintenance payment should only be awarded to alleviate significant hardship. And that's echoed by what Judge Everall says. The periodical payment should be aimed at alleviating significant hardship. So that even if there is found to be mismanagement to the point of recklessness, wantonness, or otherwise, there is a safety net, a grounding within the cases, within family law and financial applications generally. And we're familiar with it, those of us who practice in the field, that needs trump everything. It's an old phrase.
Well, Section 25 doesn't say that exactly.
It doesn't, no, but it's something which is a touchstone through all of the cases on small money cases, cases where need is the magnetic or deciding factor, that need does have that effect.
Is it still common practice for orders to be made in the circumstances of Fisher?
I haven't seen one recently, I have to say. That doesn't mean it's not still good.
No, it doesn't. That's why I asked the question.
That's right.
You do this sort of thing regularly,
Yes.
I don't. But
what tends to happen, of course, what happens very much these days, is that following a relationship breakdown and making the making of periodical payments,
you have a clean break.
there's either a clean break,
Yeah.
or there isn't remarriage and that sort of thing. There's cohabitation. There is, I think there's a great deal of fudging that goes on, frankly, in people's relationships, and people know which side their bread is buttered. I don't think I can put it higher than that, or indeed more helpfully than that. But that's where this lands. And in this case, there is first of all the question of whether being unwise is sufficiently culpable to land you in this sort of difficulty. And secondly, that even if it is, family law has always had a principle whereby the most basic needs are met even if they're not causally connected to the marriage. And that's what this case is, even if, as it were, we lose on the unwise and mismanagement point. The sums involved in this case for the wife, the consequences to her of not having this extra small amount per month, are so significant as to be significant hardship, which the authorities allow the judge to alleviate. And his only error was in not doing so. That really was what the Court of Appeal ultimately found. That he found basic needs at X and gave her X minus £341. Lord, my lady, that's all I was going to say on North, unless there are questions more about that. I was going to go on to fairness, which is partly a North point and partly a general point. But in talking about fairness, I would simply really refer you back to what I was saying at the beginning of my submissions to you, which is that fairness in this case has to be seen from both sides of the table. That the husband says, really, 50 years, perhaps, of further maintenance? Can anybody think that's fair? Whereas the wife will say, as we put in our written case, if you ask the question, when you voluntarily agree to maintain someone for life and gain control of companies which give you your comfortable living, should you be able to get out of that agreement when it begins to upset you? It's difficult, the question of fairness in this case, and it was analysed by the judge, and the fairness, he said, was that periodical payment should be aimed at relieving significant hardship, but he did not do so. So if that's how we address fairness in the North context. The two other matters I'm coming to, my lords, and I think I can do them relatively shortly, of course subject to questioning from the court, are the cases of Pearce and Yates. And both, we say, can be readily and easily, obviously distinguished from the case here. In Pearce, again, not a small money case, not perhaps the biggest of money cases the world has ever seen, but there was a flat in Chelsea for the wife and £36,000 a year on conventional terms, meaning, I think, joint lives. That was the result of the financial remedies proceedings there. The wife sells the flat in Chelsea and decides to renovate a house in Ireland. She lost £50,000 selling the property, and it seems generated a £9,000 capital debt, which it isn't fully described in the report, but which we infer was to do with that renovation project. And came back asking for an increase of periodical payments so as to meet a mortgage that she required to rehouse herself when she came back to England. It's very plain in that case, first of all, that significant hardship is not said to have been a potential consequence of having to pay her own mortgage. And that the real reason for not allowing the periodical payments to be increased to pay that mortgage was it gave her a second bite at the capital cherry. And it's very plain from other authority that there is one bite of the cherry in capital in financial remedy proceedings in this country, and to subvert that by allowing further capital to accrue by having one party pay the costs of a mortgage was simply wrong in principle. That isn't the case here. This is rent as part of a basic need. It is not accruing to yourself further capital after an order you've already received. The case of Yates is different to the extent that, as far as we can tell from the report, though it's not, again, absolutely clear, this is a mortgage which was interest only. I say it's not absolutely clear because, so the case of Yates, my lady and my lords, tab 13. MS 547. The slight question mark over whether it was a repayment or interest-only mortgage is that when asked what it was in cross-examination, the wife didn't know. And my lady and my lords, the paragraph 14 of the judgment sets out that piece of cross-examination. And on page 228 or 550, you'll see the 3 or 4 lines of cross-examination just before the middle of the page. How long would it be for until the mortgage was cleared? Any idea when? Or how long is it an interest-only mortgage? Yes, I don't know. So I don't think it was very clear, but we're taking it as an interest-only mortgage for the
Well, I think Lord Justice Lewison at 21 talks of a mortgage interest repayment.
Yes.
So I think you're probably right on that.
That is an interest-only mortgage. It is still different from here. That case is different from this for these reasons. First, setting aside the sums involved in that case, an interest-only mortgage nevertheless allows capital to accrue. If you have a property, this is 2012, if you have a property which is being paid for, which has a capital value, and the likelihood ordinarily, even in this day and age, of an increase in value, certainly in London since 2012, that must be the case. There is a capital value accruing to you when ultimately that mortgage is paid off. So there is, in any event, a capital value accrual. But more than that, in Yates, one has to look at what the award was. The wife received a lump sum of £978,000, just short of £1 million. There was a mortgage of £451,000 on the matrimonial home, which she didn't discharge. She invested a significant part of that sum in a non-interest paying bond. But she had the remainder, £527,000 as investment capital left over from the repayment of that mortgage had she done so. This was not a case in which basic needs were a problem. And so she, having taken the decision to tie up money for no return, her decision to tie up money for no return, one can see how that crosses the line from mismanagement to recklessness or foolishness. And particularly when you have the means to remedy that foolishness yourself. Of course, there is no need in fairness for the court to intervene.
Did the court in that case speak at all about recklessness or foolishness? Or
it doesn't. It doesn't really enter into it. It's just...
They didn't see it that way.
As a matter of common sense, the court said, if what you do is tie up your capital, but you've got other capital that you can use to defray the problem that you've caused for yourself,
Yeah.
why should the court interfere? So they're different cases, we say, to this. We acknowledge that they potentially cause us problems in the argument. We say so plainly in our written case. But when looked at as to their facts and comparing with the facts of this case, they don't alter what we say is those features of North, which we say led Judge Everall to the right, and that right legal analysis, but the wrong factual outcome, which then had to be corrected by the Court of Appeal because of the modest sums, the basic needs, and the genuine requirement to avoid significant hardship in this case. My Lords, those are my submissions, unless I can assist you with anything else.
I think not. Thank you very much indeed,
Thank you,
Mr. Fearn. Ms Dunseith? Mr Cagle.
Lady, I'll be brief in reply. Firstly, can we just think about the judge's findings? We've looked at the judge's findings, and I might have to take them back to you for just a moment, but what the judge found is that this wife blew, to use an emotive term, but dissipated the entirety of the matrimonial capital, almost the entirety, in a rising property market in Surrey, to pick up my Lord's description of it, and couldn't account to him for how that had happened. And he found that troubling, obviously, and it clearly affected his view of the overall fairness of the case. Can I turn you, please, to MS 149, paragraph 23 of the judgment? We looked at it this morning. Paragraph 23, he describes the husband's evidence: reliable and truthful evidence, frank about the company's prospects for the future, frank about his future budget, I accept his evidence. Over the page, the wife was not a fully satisfactory witness in her oral evidence. She was unable to give me a clear picture of her financial circumstances in the years following the 2002 order. She could not remember what she earned. Her evidence about her current health difficulties was, in my judgment, as I will recount, somewhat exaggerated. The natural consequence of what the wife did, as set out in the schedule that appears a bit later, the evidence appears a bit later in the judgment, the schedule that we set out in our written case, is that she, if you add in the latent property increases, she managed to spend, before anything earned, something in the region of £75,000 a year, perhaps a little more, between 2002 and 2009. I mean, those are the figures. And she appears in front of His Honour Judge Everall and can't tell the judge what happened to all that money. And the judge is very unimpressed with that. And that, in many ways, informs the judge's view about this case. And to revert to what Lord Wilson asked a moment ago, does it mean in these circumstances that if a wife who perhaps can't be put into the pigeonhole of profligate and wanton comes back to court, having behaved in that way, she can simply assume that the payer, never mind his financial position, that's hardly in play, can come back to the payer and say, well, you're going to have to maintain me forever because now I have a rental need. And what would happen if she came back, and Mr. Fearn draws distinctions between Pearce and Yates, but what would happen if she came back and said, well, I'm afraid I've spent all my capital, but obviously I need a property, so I want a mortgage. I've got mortgage repayments to pay. What would be the difference between that and what she does in this case by saying, well, I've blown it, but you need to support me. I'm actually renting at the moment. The figures might be the same, who knows? But in doing so, I would derive a capital benefit eventually, perhaps. What's the difference between that and the situation that friend was seeking to draw the difference in a purchase property or a capital asset from ongoing revenue expenditure? And we say, frankly, probably none. Lords, the time warp that we're dealing with in this case is, of course, frustrating to everybody, in the sense that you're being asked to decide a case on 2014 figures. It is entirely possible, I don't know, it's entirely possible that the parties' financial positions are very different today. The only way that that's going to be determined or tested, if it has to be, would be to go back to the CFC and go through the process all over again. So the decision that you're being faced with is one really of principle, but based on the facts in a particular time warp. There's no great criticism for that. And
That is the universal situation in this court.
yeah,
We only deal in points of law.
Lady,
Findings of fact made in the courts below, which sometimes are a long time ago and sometimes are yesterday.
yes.
But that's what we do.
Oh yes, Lady, I understand that, and I'm not in any way criticising that. But what you can't do, with respect, is what my friend trespass on in the early part of his submission, by saying, look at this company. In 2008 and 2009, it was generating this much cash. This is something, says his client, I was a part of. This is what I've given up. This is what he uses to ask rhetorically, how would the other side of the argument see this if you've read his question? Would that be fair if it was put the other way? This wife has given up an interest in a company that's generating that kind of money in 2008 and 2009. That's completely unfair in the sense that if you look at paragraph 34 of the judgment, just once again, for 1 second, because my friend did refer to that, it's at MS 152. What the judge says talks about the average of income, £45,000, and towards the end of the paragraph, I note in the 6th and 7th year after the 2002 order, the husband was able to draw 160, 129,000 in 28 and 29 respectively. Of course, he doesn't go on to say or deal with what that money was spent on, and had he done so, there would have been a very clear answer. But he doesn't find that this is income available to the husband, for example, as indeed it wasn't. I've set out how the amount drawn from the companies has reduced since these years. And there's a schedule which Maloney Jr. is just pulling up for us that was before the judge, which described the income pattern of the company from, I think, 2007 to 2014. Thank you very much. It's MS 985.
Otherwise known as?
Otherwise known as. Otherwise known as.
It'll be the number at the bottom of the page, probably.
Yes, well, it'll be Appendix 4. 417? 417.
Yes.
Your Lordships have it. This was in evidence in the hearing in front of His Honour Judge Everall. And there's...
Is it 988, Mr. Cayford?
My Lord, it should be 985.
All right, but anyway,
but it may be 988.
Schedule running from 2014 to backwards to
Yes, it could easily be 988.
Got it.
Yes.
Yep, okay.
Yes. Yes. Yes.
It's the very bottom line. Is it, Mr. Cayford?
It's the very bottom
On the
line,
right-hand
yes.
side, you've got the judges 160 for
Exactly.
2008, and
Exactly.
you want us simply to go across the line from right to left.
That's it. Lord, that's the point I make. And if I can't make my point about the wife being self-sufficient in 2012, which should have perhaps dealt with the entirety of this application, or certainly might have done had it been made in 2012, my learned friend can't say, look at this company, it's been turning out this sort of profit, and on that basis see what I've given up, because she says I played an integral part in the setting up of the business. Apart from the fact that that point wasn't raised in the court below, it wasn't argued with any degree of conviction that she played any material part in the setting up of the business. Apart from that, there's a number of factual issues which don't fall for your lordships to decide, of course, but it shouldn't be acknowledged or accepted that is agreed fact. What you see is that in the just about pre-Lehman period, life as a surveyor was better than it was thereafter.
Well, there's a passing reference to that in the judge's findings, isn't there?
Yes.
It's a bit oblique, but it's there at 28.
Yes, well, my lord, absolutely.
Because he says, after the partner, the ex-partner left, the net profit dropped. It's rising from 2012 onwards, which may or may not be based on this schedule, but this schedule confirms. And then there's been a loss as a result, he says, of the recession and loss of one particular customer.
Yes.
On the other hand, he thinks the husband will probably be able to replace the customer.
Yes, he is optimistic.
Yeah.
But that's as far as you can take the point. I wanted to make the point that it's a little unfair to use this rhetorical flourish about, look at this company generating £160,000 per annum, when that was 10 years ago. Well, it was, whatever it was, 7 years before the matter came before His Honour Judge Everall. It was historic. And His Honour Judge Everall noted that and very much took that into account when coming to the other conclusions that he came to about the future of both husband and wife. Lord, there's also, I just mentioned in one sentence, there are some serious factual discrepancies between, I suppose, my case and my learned friend's case, in the sense that he talks about parenting and he talks about school fees. And I think you will know from what you've already read that the bursary came along in 2007 and paid the wife's agreed share of the school fees. So she didn't, in fact, have to pay any school fees from 2007 onwards. And that the husband paid the rest of it, the other 2/3. I only say that in mild rebuttal of what's been suggested. And the figures, Mr. Fion's figures this afternoon are correct, more accurate than this morning's. I was going to make that point, but he's made it for me. And there is an issue about the extent of parenting of the child, which again is not something that I want to do anything more than just say that it would be very unfair to leave you, or for you to be left with the impression that this was a case where a father had absented himself or had not played a full role in the looking after and the bringing up of the child. I'll leave it there. I therefore turn to the question of the test and what's the answer to the North conundrum. And it seems to us that learned friends trying to bring the bar down from whatever it might be, recklessness or extravagance or mismanagement, to well, if she's in that position, that's bad luck. But nevertheless, the husband ought to continue to pay. We say that so far as the language of North is concerned, this is really semantics. One's got to look at what's actually happened and whether or not it's reasonable for a judge, and here we're talking about the judge with his Section 25 discretion, whether it's reasonable for him to say, well, I'm sorry, it may be difficult for you. It may be that the item of your budget that deals with a new car is going to have to wait. It may be you are going to have to find some other way of either making up your budget or spending a bit less. And I took you through the budget this morning and showed you that there are certain items in the budget that aren't set in stone. And it wouldn't be right to say either that the judge took the budget as set in stone and something which had been proved. It was simply the budget figure that was put before the court on day one of the hearing and to which the parties worked. But clearly, £35,700 odd a year by way of a budget for a person who is now effectively a single person is not abject poverty, and it can be described as basic minimum needs, perhaps in relative context. In other contexts, it would be described as a fairly moderate or a fairly reasonable budget. These things, as your lordships know, are always relative and subjective, and it isn't perhaps often that lower money cases come before you and that you have to worry about issues like this. But I can't let my learned friend get away with saying this is an absolute basic minimum needs case, and if this wife, his client, goes away from this court with less than her £2,982 a month, she will be in dire straits. That's not what the judge found. And on analysis, it's not really a fair comment. The broader test, really, for for those cases, and indeed all cases, is one that the judge must set himself. Is it a question of fault? Mr. Fearn says that this is going back to the old days of matrimonial conduct or something of this kind. I wonder if that's right. If there is a disadvantage suffered, in this case by her, is an element of fault to be attributed? Is it right to say that you can distinguish Yates, because Yates is the cleanest and simplest authority for the proposition that if the wife made a choice and suffered financial consequence, she should be the one to shoulder the burden? If the wife's aspirations were in fact what caused this shortfall, if the judge were to take the view, perfectly reasonable view, and you can find it in the judgment in several places, that what she did was overextension, okay, other people did it too, but the judge hasn't said that all people who extended their mortgages to that degree ended up in the sort of financial difficulties that this lady did. We don't really know. We haven't got the evidence as to quite what she was spending, the 75, maybe 100,000 a year, depending on what she was earning at the time. We don't know what she was spending it on. But what is perfectly clear is that as the mother of a young child, she was making aspirational purchases during that period of time, which ended up going very badly wrong for her. And it's perhaps not totally surprising if one looks at the scale of the mortgages involved on the basis of her income. We're dealing here with a minimal budget, it said, but I wonder what one would have to show to a building society, or the Northern Rock in this particular case, to justify a mortgage of £442,000. It's not something we can give a definitive answer to, because there's been a great mass of evidence that just isn't in the case. But what do you have to say to a building society to get a mortgage of that kind? What does your income have to be? It can't be £13,200 per annum, that's for sure, unless there's something we don't know. So it's reasonable, is it not, for a judge to impute a certain sense of irresponsibility or choice or bad decision-making into getting this lady into the position that she is. In Yates, we would say, with respect, that there really is no threshold at all, to answer the Lord's question. There's no threshold, and it's not a bad comparison to make. Obviously, you've been shown the three cases that appear to deal with this issue as best as any of them can. They're not identical, they're not on all fours. But in terms of the approach of the Court of Appeal in Yates appears to have taken the view, you'll remember the passages, that it was effectively her decision, no particular fault, her decision, consequences, her liability. And it won't really do in these circumstances to say, but that was not a basic needs budget case. This lady knew that she was dealing with a basic needs budget case, if she was, and that's again not necessarily established, at the time that she was doing this. Every day she would have been entitled as a competent and capable adult of looking at her finances and wondering whether what she was doing was the right thing, whether it was sensible, whether it was responsible so far as her child was concerned, whether it was responsible so far as the paying party was concerned. What would happen, for example, if the paying party fell under a bus at the time that this lady was taking on a mortgage of £442,000? Was she relying on his maintenance to pay it or not? What was the position? And since she appears to have been caught out, and one might say hardly surprisingly, and since even in those circumstances she's not able to tell the trial judge, the 2015 judge, quite how all of this came about, how can it be fair, and I don't want to put this rhetorically more than about once, but how can it be fair in those circumstances for the husband simply to pick up the pieces in those circumstances and continue to pay to a level of what this lady describes as a moderate budget? It can't be. Lord Hughes asked what happens in practice in a situation like this. And My learned friend said, well, there tends to be a clean break, or there's cohabitation, he said. The parties sort themselves out, or the parties, I think he said something to the effect, the parties know what the form is, or something of that kind. We're not going into all the research that's been done on the level of maintenance orders made and the trends of maintenance orders being made, but it may be that a number of those receiving maintenance payments are fully aware of the position under law and what does in fact actually happen. We don't know in this case anything other than what's set out in the wife's evidence about her own position vis-à-vis cohabitation or anything of that kind either. We don't know. I'm not imputing. I'm saying that there is a reference to a long-term partner at one stage. Maybe that was true. Maybe it wasn't. Maybe it came. Maybe it went, and we don't know. But there's an absolute absence of evidence about that. And one of the things that we complain about is the difficulty, I won't say unfairness, the difficulty of a genuine and properly motivated paying party when he doesn't know what the position is. He doesn't know what the financial position is.
Yes, you made that point earlier.
I did. Well, I won't make it again. So, my lady, we say that Pierce is effectively a second bite of the cherry, and I go back to my mortgage analogy. Yates, there's no threshold at all. It's just a question of who did it, who was causative. And finally, my lady, I'll just say this, that in terms of fairness, which my learned friend did introduce into the debate towards the end, it's obviously a very circular concept, and it's a concept that's been discussed by this court, obviously, since the year 2000 and well before. And it may well depend on your point of view. It may well be, as Lord Wilson observed in his address, that from a particular point of view, the net effect of this order is desperately unfair. It may be that from the point of view of the wife in this case, that to have the order of Everall restored would be desperately unfair. And I'm not quite sure how one puts it to this court, other than to say, well, actually, this has now to be a matter for you, because if Lord Nichols, and indeed my Lady Hale, described and analysed and discussed, and Lord Hope, of course, the concept of fairness in those early cases, I say early, some 10 years ago. If that is to be the leitmotif of any decision that comes from this court, it will be a matter for your lordships to decide whether any of this is fair or not.
I expect I'll be involved as well.
Lady, of course. I wasn't suggesting for a second that you wouldn't. You will, of course, be involved in this decision as to fairness.
No, I was merely making a joke at the expense of your perpetual referring to the bench as my lords.
I'm sorry, my lady.
That's all I was doing.
Yes. Well, I hope you don't normally have to make that joke, and I hope it's just me who's being particularly unsympathetic about my address to you, but I didn't mean to do that either. You have to decide, you have to stand back and decide whether or not the net result which the Court of Appeal has produced is fair or not fair. You have to decide whether the result that His Honour Judge Everall, after this length of time, the two days of thinking about it and a reserved judgment, was fair or not fair. And you have to decide whether or not this husband should be penalised, and I'll put it as high as that, penalised by having to pick up the pieces of this wife's conduct, her actions, whether they be mismanagement, profligacy, wantonness, whatever, it doesn't really matter. Is that the right result? And is that a message which this court is happy to send out to the litigating classes and the world of matrimonial finance? Is this right? We say this is not right. We say this is very unfair and shouldn't be allowed to happen. At the very least, therefore, the appeal should be allowed. And if your lordships will not give any further guidance to the legal classes, so be it. But at the very least, this appeal should succeed. My lady, is there anything else I can help you with?
It appears not. Thank you very much indeed, Mr. Cavin. Thank you. Well, this is an appeal on a very restricted basis. We have no jurisdiction to deal with. It's not that we might not want to, it is that we have no jurisdiction to deal with anything other than the appeal on the ground that it is. And we will now go away and make the best we can of the very interesting arguments which we have been presented with. And we're grateful in particular to counsel and those who haven't been on their feet, who I'm sure have contributed to those arguments. The court will now adjourn.